Hey patent friends, welcome back to another video. A question I get asked a lot is being a patent attorney a good job? So this video is going to explain why I love being a patent attorney, give you all the details on that, and then also sort of the realities of why it's, not a perfect job and why it may not be great for everybody. So stick around, we are starting right now. So for those of you who are new here, my name is Dylan Adams. I am a patent attorney and author of the best-selling book, Patents Demystified, which is an insider's guide to protecting ideas and inventions used by inventors, entrepreneurs, and startups worldwide, including at top universities like Harvard, Stanford, and MIT. It's also used about folks who are curious about patent attorney careers, including folks who are just getting out of undergrad or people who are law students who are exploring patent attorney careers. If you're looking for more content about patent attorney careers, be sure to subscribe to the channel, hit that little bell icon so you don't miss any great videos. So, all right, let's get right into it. So the simple answer to the question of whether being a patent attorney is a good job is yes. I mean, I love being a patent attorney, and let me kind of tell you why. It's a great job if you're into technology, and as far as law jobs go, it's pretty amazing. So for instance, for me, like, I get to geek out on technology all day. My clients are inventors, entrepreneurs, and startups. People are excited to come and talk to me about their inventions and about their businesses. In contrast to folks who I know who work in family law, where they deal with a lot of contentious situations and it's really emotionally charged, or people who work in criminal law and that can be kind of draining. You don't see people at their best times in their lives. And while these folks obviously, really help people, it can be the kind of law practice that is really draining on folks. Whereas for me, it's, by and large, it's a really positive thing. I mean, like I said, my clients love to come see me. They're always telling me about their new stuff. It's a very positive thing. I'm creating value for the company. I mean, I would say a lot of times, the money that they spend on patents, they're making, 10 times that in the end in terms of value that it brings to their company, if not more. So, I'm kind of one of the few attorneys that actually is positive for people, instead of like, oh, we're defending against lawsuits or having to deal with issues. And, the attorney is really the only one who's, making money on this. It's a negative thing for the business. It's a very positive kind of thing. Another thing that is great is that patent attorneys tend to have a fairly flexible schedule, in the sense that we get office actions from the United States Patent and Trademark Office during the examination phase, and we'll have at least 3 months to respond, and that can be potentially extended by an additional 3 months. So you really see things coming. It's not like litigation or other practices where you have to respond in 15 days or 30 days and you don't really know when things are going on and things are on fire and you have to respond immediately. A lot of times, I can really control my schedule because I see things coming out. And so for instance, if I want to go on vacation, I can go on vacation. And a lot of times, honestly, I won't check my email the whole time, and I'll just rely on, hey, if there's some sort of emergency, which a lot of times there isn't, that, somebody will text me or call me on my cell phone. But by and large, I can totally unplug. Whereas a lot of other attorneys, they have to be involved and they have to a lot of times work on vacations. And I know some folks, especially people who are litigators, they have something come in during a vacation or before a vacation. They either have to cancel the vacation entirely, or they actually have to work on vacation and never get to hang out with their family. For me, by and large, I have great separation between work and life, and I work pretty much like a 9 to 5, 9 to 5:30 every day. It's easy for me to check out after that. And then really take off weekends. I mean, very rarely do I work on weekends, and very rarely do I even check my email on weekends, which is pretty rare for a lot of jobs, and especially law jobs. Those are the many things that I love about being a patent attorney. So obviously, like any job, being a patent attorney is not perfect, and there are, of course, downsides. And I would say, one of the biggest things is probably the amount of workload. Lawyers tend to work long hours. It's like it tends to be like 9 to 5 or 9 to 6:30, or, but it tends to be a lot of work, and there can be stress involved, having to worry about deadlines and client expectations and bills and things like that. Obviously, that's not always totally pleasant. And having to deal with every once in a while, clients are unhappy about things or don't understand stuff. They jump to conclusions, and there's misunderstandings. Having to deal with bosses. I mean, I'm lucky now. I'm a partner at our firm, and so I have less to deal with that. In terms of having bosses. But at the same time, having to supervise people and manage people, that's difficult and not always enjoyable. You know, the people side in some ways is the most difficult aspect of being a patent attorney. And so, you know, there's always going to be those natural pieces of just it being a job that's not always perfect. You know, having to deal with, you know, every once in a while that, you know, there's things like office politics and you know, just, you know, interpersonal issues. I mean, at my firm, I'm pretty lucky. We have very little, if any, of that. But I've been at firms, especially sort of smaller firms, where there was a lot of office politics, and you know, I wasn't always very happy because of you know, sort of interpersonal issues with people who are bosses or people who are staff, and you know, that's going to be in most jobs. When it comes to the day-to-day work of a patent attorney, it may not be right for everybody. So, for instance, what I do a lot is writing. A lot of what I'm doing is writing. So, a major portion of being a patent attorney is drafting patent applications, which are highly technical documents that describe inventions in great detail. So, for instance, to be a patent attorney, you have to have a technical background. I have a master's in electrical engineering and an undergrad in biochemistry and molecular biology. That allowed me to sit for what is called the patent bar, which is required for an attorney to be called a patent attorney. So I had to take the bar, which happened to be in Washington State, and then I also took what's called the patent bar, which allows me to be a patent attorney and practice for the United States Patent and Trademark Office. So I have this technical background, and I use it all the time to draft these highly technical documents. If you're somebody who doesn't like technology and doesn't like writing and doesn't like writing about technical things, maybe it wouldn't be a very good job for you, because you know, you're going to be writing a lot of highly technical documents. I mean, it ends up being, you know, at the bare minimum, it's going to be maybe 10 pages, but usually it's going to be in the 30, 40, 50 page range, up to 100 pages of technical documentation, including description and drawings. So if that's something that doesn't seem very attractive to you, maybe being a patent attorney wouldn't be that great. The other side of what a patent attorney is working patent applications through the examination process at the United States Patent and Trademark Office. And the way that works is, so you file what is called a non-provisional patent application. That application waits in line for 1 to 3 years before a patent examiner at the United States Patent and Trademark Office picks it up and does a prior art search to determine whether what you have claimed is new and non-obvious compared to the prior art that's out there. And that could be issued patents, pending applications that have published. It could be actual products or scientific papers. I mean, really any sort of technology disclosure. Question is what you have claimed new and non-obvious compared to that? And so there's this negotiation with the examiner. So it's important to realize that patents are it's not just a binary thing where you have a patent or you don't. You can have a scope of protection from being really broad to covering a lot of variations, including your product, so that it's hard for other people to design around the patent. Alternatively, you can have a patent that is so narrow and so specific that somebody can make tiny, unimportant changes and easily get around your patent. And that's what the negotiation is with the examiner. And it's a natural and expected part of the patent examination process. Kind of like, you know, if you're in a negotiation, you're haggling over something. Kind of like in Pawn Stars or American Pickers, there's always going to be a negotiation where the buyer and seller kind of come to a point and hopefully come together on a price that, you know, satisfies both parties. And that's sort of what's going on with the patent examiner. As a patent attorney, you're trying to get the broadest claim coverage possible to cover a lot of different variations, which makes the patent stronger. But the patent examiner has to hold you to that standard of it being new and non-obvious compared to the prior art. So there's a negotiation to make sure that, you know, you're trying to get the broadest patent, but at the same time, you know, it meets the standards for patentability. Now, it's actually pretty chill when it comes to these negotiations with the examiner. And yes, they do have rejections and you have to review them. But it's usually not a very contentious sort of relationship unless you decide to make it that way. The patent examiners, they are not attorneys. They're people who have a degree in, you know, some sort of technical engineering or science, and you know, they're not usually contentious people. Some are, for sure. There are definitely examiners who, you know, they can be really rude and pushy and be like, I don't want to give you a patent, and they can be, you know, more aggressive than patent attorneys can be. But by and large, these folks are trying to help you, and if you kind of go about the relationship that way, they're there to help you, and they're positive, and they're excited, if anything, that, you know, you're not being aggressive and confrontational with them. And so, you know, you do a couple of things. One is you're going to draft written responses. Again, it's going to be a lot of drafting. There's a bit of analysis, of course. You have to, you know, analyze what's in the patent application, whether you wrote that or not, or whether somebody else wrote that. You have to analyze what's in the patent application. You have to analyze what's in the prior art. analyze the arguments that the examiner presents in these office actions, and decide whether you want to argue against the rejections or amend the claims in your patent application to differentiate over the prior art. You can call the examiner up, but usually those aren't really long conversations. That doesn't happen all the time. I'll do, sometimes a few patent examiner calls a week, but a lot of times I structure it so it's really short. We know what the issues are, and, we can kind of hash things out in, sometimes 5-10 minutes. Other times it can be longer meetings, but usually it's going to be, probably a half an hour, and that doesn't happen that often. A lot of times it's going to be written responses where you have, several pages of argument and you have amendments to the application. So again, if you're not into writing, if you're not into doing a bit of analysis on technical things, maybe being a patent attorney isn't really for you. One of the things that a lot of people think is, oh, hey, a patent attorney goes to court all the time and, they're doing litigation. That's a patent litigator. And while there are some patent attorneys who do patent litigation or have it as part of their practice, a lot of times people who are patent litigators, they're just regular attorneys. They don't necessarily have a technical background. They haven't passed that patent bar. They're just regular folks who do patent litigation and focus on that. And so, for instance, for me, like the last time I was in court is when I got sworn in to be an attorney. I never go to court. I've done some patent litigation, but even that, that's really just sort of, drafting a complaint and filing a lawsuit and doing discovery and doing analysis. You never really go to court. So if you're looking for a job where you're going to be in court and you're going to be, out and you're going to be litigating things and it's going to be a really verbal kind of thing, patent attorneys typically don't do that. When it comes to your typical patent attorney who's doing the drafting applications and the examination process. But at the same time, you can still pass the patent bar and be called a patent attorney and choose to do other sorts of law. Some patent attorneys, they take on things that are general intellectual property. So intellectual property covers patents, trademarks, copyrights, and trade secrets. And they may do additional things like, do trademark applications or maybe do some licensing, do some consulting on trade secrets, things like that. I tend to focus pretty much on patents. I like to, refer things off to people who are specialists. And I am at a firm where I have people who are specialists in trademarks, in copyrights, in patent litigation, in licensing. And so I can refer those things to people who really know what they're doing. What I am really good at is drafting patent applications, planning patent protection, and then the examination process with patent examiners. So, that tends to be what most folks do, but, there is, some variability and there's not always a one-size-fits-all type of practice. There's other sort of folks who are patent attorneys. Those would be in-house patent attorneys. And so an example of this would be, so like at a big company that has a really big patent portfolio, as in, hundreds, if not thousands, and maybe tens of thousands of patents and patent applications, they actually work with outside counsel like me, somebody at a firm who's a patent attorney. They kind of coordinate with the engineers and scientists, hook them up with the outside counsel patent attorneys like me, and help sort of plan the overall portfolio and sort of review work product and make sure that things are going in the right direction. That tends to be more of a managerial sort of role, and something that, I always thought was a standard thing that, you work at a firm for a long time and then you go in-house. But I don't know, I became partner at my firm and I really like my practice. I like having a bunch of different clients instead of just one client, which is the company that you work for. I really like the diversity of working on a lot of different stuff. Like for me, on any given day, I might be working on cloud computing or cryptography or databases or robots, consumer products, heat exchangers. Really anything. I have a quite varied practice, which I love. I enjoy the diversity of things. Some people, they like to focus on one thing. I know some people, for instance, like all they do is microchip manufacturing, and that is their niche and that is their focus. Not really for me, but some people have these hyper focuses in their practices. So there is a lot of diversity, but when it comes down to it, you have to kind of think about what the basic job of a patent attorney is and what the environment is, and it's a lot of writing. And then in terms of office versus remote culture, being a patent attorney really does allow for the potential to be working remotely and not having to go into an office. So for some attorneys and some folks, they have to be in the office 5 days a week, and it's essential for them to be there. It's a really collaborative thing with staff and other attorneys, and so that physical presence is essential. Whereas for me, I can really be remote. And to be honest, I haven't been to the office since 2019. I've spent my time, especially during this pandemic. I've been at home, and my practice has sort of been easily adaptable to that. Because I can work with the patent office, which is in Virginia, and I have a lot of staff. They're in New Jersey, and other folks are in LA. Even though I'm based in Seattle and we have a big Seattle office, I haven't needed to go in. At the same time, there are attorneys in my firm who are patent attorneys who like to go in all the time, and they like to work directly with folks. So you at the very least have the option for both. It depends on the specific firm you're in and sort of the culture that your firm has. But at least for me, I really have the option where if I wanted to go in the office every single day and have a nice office, I could totally do that. But I choose to be pretty much fully remote, which I really love and fits my personality. And that's something to consider as well, is that, even if you do go into the office, a lot of times being, a patent attorney, it can be kind of solitary. You're kind of by yourself, you're drafting applications, you're doing analysis. It's not a super collaborative thing. Obviously there's some collaboration with, with staff, and, if you're managing folks or if you're getting work from, from someone else, there's going to be collaboration there, but it's not tons of collaboration like some other practices can be, which for some people is a huge benefit. Other people, they want to, interact with a lot of people and be on teams. So that may be something that may not be attractive for everybody. So I absolutely love being a patent attorney. It's definitely a career that I recommend to everybody. At the same time, it's a job and it's not always perfect, but I think it's absolutely fabulous. I get to geek out on technology all day, get to work with great people like inventors, entrepreneurs, and engineers. I just absolutely love it. But at the same time, you have to consider, does it fit your personality? Are you somebody who likes to do a lot of writing, whether it be, drafting patent applications, doing Office Act responses and arguing against rejections at the patent office, doing just the basic emails, which there's a lot of that going on. Is that the kind of thing that you're interested in? And it tends to be kind of a more solo sort of thing. There's not always a lot of interaction with folks. Some practices are, but a lot of times, it's kind of you just doing your work by yourself. Some people love that, some people hate that. So if you got some value out of this video, please give it a thumbs up. I'd really appreciate it. And for more content on patent attorney careers, be sure to subscribe to the channel, hit that little bell icon so you don't miss any important videos. And thanks for watching. We'll see you again in the next video. Cheers.